Welcome back, KSLU law students, to this exam-oriented explainer blueprint. I am your host, and today we are going to completely dissect question 22 so you can secure absolute maximum marks in your property law finals. All right, let's dive right into this. Listen, for your exam, precision is literally everything. You simply can't afford to write these vague, meandering paragraphs. You need structure, you need authority, and you need to give the evaluator precisely what they are looking for on that answer script. So listen carefully and note this mandatory structure down. Your script must follow this exact sequence. 1. Introduction and definition. 2. Essential elements. 3. Modes of creation. 4. Rights and liabilities. 5. Termination and illustrations. And finally, 6. Landmark case laws. Okay, starting right off with Section 1, Introduction and Definition, governed by Sections 105 to 117. Now, when beginning your answer, please never just start writing without citing the Parent Act. Setting the statutory context immediately tells the KSLU evaluator that you are a serious student of law. A lease under Section 105 of the Transfer of Property Act is this: a transfer of a right to enjoy immovable property for a certain time in consideration of a price paid or promised or money, share of crops, service, or other thing of value. Write this out verbatim and literally underline right to enjoy on your paper. That right there is the absolute crux of it. A lease is not a transfer of absolute ownership, right? It is purely the transfer of the right to enjoy the property. Immediately below that definition, I want you to draw a very clean visual comparison on your answer sheet, clearly establishing the parties. You put the lessor, the transferor, on the left, and the lessee, the transferee, on the right. Visually separating these terms proves you have fundamental clarity before you even begin to discuss the complex mechanics of the actual transaction. Moving on to Section 2, Essential Elements. These key components must be listed in distinct, unmerged bullet points exactly as they appear. Memorize these 4 precise elements. First up, transfer of right to enjoy, not ownership. Second, the property must be immovable. Third, consideration, which can be rent or premium. And fourth, a certain duration. Missing even one of these points is going to cost you precious marks. Why? Well, think about it. If there's no consideration, it's just a gift, isn't it? If it's not immovable property, the Transfer of Property Act doesn't even apply here. And if there's no certain duration, the legal nature of the enjoyment is completely compromised. Next heading on your exam paper, Section 3, Modes of Creation, strictly governed by Section 107. Always cite the section numbers right there in the headings themselves. It projects immense confidence. Note these 4 specific modes. Number 1, by registered instrument, and explicitly point out that this is mandatory when a lease is greater than 1 year, is on a year-to-year basis, or reserves a yearly rent. Number 2, by oral agreement plus delivery of possession, which is permissible only for leases less than 1 year. Number 3, by holding over under Section 116. And number 4, by implied lease, created by the conduct of the parties. Instruct yourselves right now to specifically cite Section 116 when describing a tenant continuing possession via holding over. That's where the lessor accepts rent after the expiry, thereby implying a new lease. Evaluators are strictly looking for Section 116 there. We now arrive at the absolute bulk of question 22, Section 4, Rights and Liabilities under Section 108. You absolutely must present this massive block of information in a highly organized tabular format on your script. Let's look at the lessor's side first. For rights, 1. Right to rent. 2. Right to terminate the lease on breach. 3. Right to recover possession. Now for liabilities. 1. Disclosure of material defects. 2. Duty to give possession. 3. Ensure quiet enjoyment. By drawing this rigid framework on your exam script and contrasting the lessor's right to extract rent against their strict duty to disclose material defects, you show true academic rigor. It proves you genuinely understand the mutual reciprocal nature of property contracts. Now moving over to dissect the lessee's side of the matrix. For rights, 1. Right to enjoy the property and the benefit of accession. 2. Right to make necessary repairs. 3. Right to sublease or transfer interest and remove fixtures. And for liabilities, 1. To pay rent and maintain the property. 2. Not to commit waste. 3. To restore possession on termination. This brilliantly illustrates how the law balances power. Explain to the examiner how the lessee's right to sublease directly balances against their absolute strict liability to restore possession on termination and to not commit waste. The property must be returned just as it was given. All right, pivoting now to Section 5, Termination and Illustrations, under Section 111. To bring the mechanical part of your answer to a close, you have to briefly state how a lease ends. Law isn't just floating theory, it's application. Dictate these 4 specific methods of termination to memory right now: by affix of time, by forfeiture, by surrender, and by notice. Just list them clearly without unnecessary rambling. The examiner knows you know them, so keep it crisp.
Following those termination methods, you must provide concrete illustrations. First example, A leases land to B for 5 years via a registered deed resulting in a valid lease. Second example, B continues after expiry, and A accepts rent, resulting in a lease by holding over. Writing down these specific A and B scenarios proves to the KSLU evaluator that you possess true conceptual clarity. It takes the abstract law and transforms it into a tangible fact pattern.
And finally, Section 6, Landmark Case Laws. Students, give me your absolute focus right now. This final section is what separates average answers from distinction holders. Never bury a case law in a block of text. On your exam sheet, write this citation: Associated Hotels of India v. R.N. Kapoor. Draw a literal box around this name with your pen to immediately capture the evaluator's attention for your 16-mark answer.
Let's do a deep case law breakdown here. The core ratio decidendi distinguished a lease from a license. So, what were the brief facts? This involved a person occupying a room in a hotel to run a hairdressing salon. The legal question was whether this was a lease or merely a license to use the space. The Supreme Court laid down the crucial exclusive possession test. The final verdict was that if a document gives only a right to use the property in a certain way, while possession and control remain with the owner, it is a license. But if it grants exclusive possession, it is prima facie a lease. The absolute relevance of citing this case is that it proves you understand the very boundaries of Section 105, showing exactly what a lease is not. Your exam tip: write this background in 3 crisp sentences directly under your boxed citation. To build out your legal argument even further, again, use that boxed format for this second mandatory citation. KC Itup & Sons v. Anthony. Underline it. This case clarified the requirement of registration for leases. Here is the deep breakdown you must write. The facts here involved an unregistered lease deed where the tenant was actually put in possession and started paying rent. Now, under Section 107, a lease for more than a year simply must be registered. Because it wasn't, the deed itself was legally void. However, the Supreme Court delivered a brilliant ratio decidendi. They held that despite the unregistered document, an independent implied tenancy from month to month was created by the sheer legal consequence of the landlord accepting rent. The absolute relevance here is that it perfectly illustrates the strict mandate of Section 107 regarding registration, while also showing how Sections 106 and 116 operate together to protect parties through implied leases based on conduct. Citing this shows the evaluator you actually understand how the different sections of the Act interact with each other. Wrap up your answer script exactly like this. A lease transfers only the right to enjoy property, not ownership. The rights and liabilities of lessor and lessee ensure mutual obligations and legal certainty in property transactions. And I'll leave you with this provocative thought to ponder for your exams. If a lease only transfers enjoyment and not ownership, how heavily does this legal certainty protect the foundation of everyday commercial property transactions in our society? Think about it. By balancing rights and liabilities so rigidly, the law ensures commerce thrives without ownership ever being unlawfully compromised. Memorize this framework, follow the structure strictly, and you are going to absolutely ace question 22. Good luck with your studies.